our annual presentations of policy issues. We're going to be doing this for the next 6 meetings. This week, we're looking at affordable housing, the issue of affordable housing, particularly tonight about NIMBYism and the role that it plays in local adoption of affordable housing. So I'm going to turn it over to Shoshana Levy, who's the project manager for this group. And then in the course of the evening, our stakeholders and our client will be introduced. We'll save it till then. Okay, so it's all yours, Shoshana.
Hello, good evening. Thank you so much to our client and our stakeholders for making it out. Our issue that we're presenting is how NIMBYs impact affordable housing development. It's an issue that isn't as well studied, especially on the empirical level, but we have found a robust body of research still suggesting that it is a big problem and impeding affordable housing development in California. So we are going to present our overview of what we think the problem is, followed by 3 policy alternatives, and then a final recommendation. It's not clicking, sorry. Yeah, it's not working.
Down.
Oh, down. Okay. Okay.
Down.
Okay. Sorry about that. All right. So for our agenda tonight, I'm going to start with the introduction, which is an overview of the problem that we are seeing, along with how we will be analyzing this problem and our policy alternatives. And then we will move to discussing the alternatives we presented and then conclude with a final recommendation and then the panel discussion that we will have where we can flesh out these issues a bit more with our stakeholders. So I'd first like to introduce our client, Erin Stumpf, who is also from Sac State. She got an MPPA here, and she is also a broker associate at Coldwell Banker Realty and a commissioner for the Art and Arcade CPAC, which is a council that frequently deals with NIMBYs. They review projects at a neighborhood level. So NIMBYs frequently show up to that commission. So she has firsthand experience responding to NIMBY comments, especially opposition to affordable housing. So our problem statement, we are basically posing that we believe NIMBYs have too much influence over affordable housing development in California, much more than YIMBYs, which is yes in my backyard. And so we think because of their extreme influence over these projects, it's harmed their ability to move forward and be built. And to add some more context to that, our Department of Housing and Community Development in California has estimated we need about 2.5 million more homes just to keep up with the need. Okay.
Test.
Sorry. So we will need 2.5 million more homes just to keep up with the need, and about 1 million of those need to be restricted at the affordable level. However, there is an existing body of research showing that NIMBYs oppose affordable housing because it impacts their property values. They're concerned about having affordable homes, especially apartments for rent in their neighborhood, because they might drag down the property value. And some other research also shows that they view themselves as defending their neighborhood. It's not just protecting their property values, but protecting the community aesthetic. And they use several tactics to oppose affordable housing development. Some of those tactics include voicing opposition at public meetings, which is a very well-known NIMBY tactic, but they also abuse what's called the California Environmental Quality Act, for example, by filing frivolous lawsuits under that law, or by using the environmental process to bring up multiple concerns while it's being reviewed at the local level, posing them as environmental issues when they aren't necessarily. In addition, another tactic that they will often use, that we've seen in the research, is placing referenda before the voters to stop affordable housing projects from moving forward. And they will also attempt to elect like-minded individuals to the local planning commissions or the city councils or the county board of supervisors and other local bodies that approve these projects to harm their ability to move forward. And while there is no quantitative studies showing how much NIMBYs empirically impact housing development, there are qualitative studies that show in-depth interviews with developers and city staff and officials stating that they receive frequent opposition to their housing projects, and as a result, they might be delayed, stopped, or curbed. So they might have to reduce the housing project significantly just to deal with the NIMBY opposition. However, as I stated, the research isn't we're unable to actually connect the number of housing units that are stopped as a result of NIMBYs, but it's something that we're trying to work out more in the research. But there is an existing body showing that there is a problem, and they will use multiple tactics to try and stop these projects, even if there are no associated number of units yet established. So to sort of continue summarizing the problem. So when NIMBYs actually stop projects, there are a number of consequences. When we have less housing, it's going to push more people into homelessness. So that's a severe consequence our state is dealing with every day. And we get multiple complaints from California constituents about how pervasive the homeless problem is. In addition, it can also impact urban sprawl. When we have especially less dense affordable housing projects being built, people have to commute more to their jobs, and they might commute from quite a distance. And so that can really impact how our urban communities are spreading out, since people cannot find affordable housing in the city they work in, for example. And then finally, when we lack affordable housing in our neighborhoods, it can really impact diversity. And by allowing people to continue to self-segregate, and as a result of what's called de facto segregation, where it's not in law legal to actually segregate communities anymore, but as a result of past patterns of segregation and continued desires to live amongst wealthier neighborhoods, we still see these patterns of segregation spread out across our communities, and that can result in things like less diverse schools. And we have seen that less diverse schools tend to have impacted performance, and that can harm our students' learning, which can then harm their current career, their future career and higher education prospects. So we illustrated all of this out on a diagram to show how these causes of NIMBYism, their desire for their high property values, potential racism and classism, and the different tactics they use to curb affordable housing projects, how that can actually result in a major problem within our housing crisis. We see that it's not just only we're seeing worsening homelessness, but persistent patterns of segregation, and then lack of proper representation at local meetings. Oftentimes NIMBYs are a very present voice at these local meetings, but we fail to see that same level of presence from YIMBYs or just from other non-NIMBY voices. So it can produce distorted views at local meetings. And so you might ask, why should the government intervene? So our Department of Housing and Community Development did estimate we need about 2.5 million more homes, but an independent firm did an analysis and they think it's more like 3.5 million more homes just to align the California people to home ratio to other states in the country. And so for that reason, addressing the housing crisis is of the utmost importance. And as a state, California needs to pay attention to these very much real causes of affordable housing development suppression, such as NIMBYs not wanting these homes to enter into their neighborhoods. And then in addition, we also have the highest total homeless population in the United States as measured by the point in time count. And so to summarize all of that, the state government has a responsibility to increase housing to address the housing crisis so that we can then start to tackle the homeless crisis. And addressing NIMBY's undue influence on affordable housing developments could be one way to accomplish that goal. Here I've included a diagram that just shows a comparison of homeless people per 10,000 residents, state by state. So California does not have the most homeless people per 10,000 residents. We have the most total, but we are right up there. So only Washington, D.C., New York, Vermont, and Oregon surpass us. We're right up there, I think, at number 6. So it is a growing problem, and I think that we will start to climb up the ladder and one day reach the top if we don't do something to increase affordable housing options. So before we get into the policy alternatives, I wanted to review how we will be rating our policy alternatives. We have 3 major criteria we will be looking at. The first one is efficiency. So how cost effective is the policy alternative? That's not just which one is the cheapest, but how many homes do we get for the amount of money we're putting in? And we have a 1 through 5 scale to judge that. And then second, we will be looking at equity, and we are measuring equity to show how many affordable housing units may be added to what we're calling high opportunity neighborhoods, which are neighborhoods that have a lot of jobs and they have low crime and they have good schools. So in order to increase access to these really nice neighborhoods, we should be focusing on building affordable housing there and not just in neighborhoods that have been underinvested in, because that might entrench existing patterns of segregation even further. So we also have a 1 through 5 scale to indicate how much progress we're making on those units being put in those particular neighborhoods. And then lastly, we're also going to look at administratability. So how easy or realistic is it to implement this policy alternative? And that is also on a 1 through 5 scale. Scoring a 1 would require something like a brand new state department that would be excessive in cost and difficult to write new regulations for, whereas a 5 would be something like a local department could absorb the costs and the implementation and make new regulations, if new regulations are needed, relatively easily. And we will also be weighting the criteria, weighting our criteria. So because many of our policy alternatives we found are not incredibly costly, we decided to weight it at only 30% and get so that we could give a heavier weighting to equity, since we are most interested in increasing affordable housing in these neighborhoods that are typically occupied by NIMBYs. And then lastly, we will be weighting administratability at 25%. Also, again, because a lot of our alternatives did not have stark implementation problems, we wanted to give some more weight to equity and less to administratability. So all of this, which my teammates will present later, will be summarized in what's called a CAM. And it will basically show how, in our eyes, the policy is rating in terms of our criteria, and then multiplied by the weight to get a final total for each category, which we will then total for every policy alternative and use that as one of the bases of our final recommendation. All right, and that is about my time. I'm going to pass it off to Shannon, who's going to introduce our first alternative.
Okay, how's that volume? Everyone hear me okay? Okay, good. Hello, everyone. I'm Shannon Swanson. I will be walking you through our first alternative, which is public debate reform. The overarching goal of this alternative is to modernize our mechanisms of public review in order to not only increase the production and approval of much needed affordable housing in California, but to include previously historically marginalized groups into this conversation and to mitigate the influence of the privileged few, those few, of course, being NIMBYs. Now, public forums, as we know, are dominated by NIMBY attitudes. They monopolize the conversation and they monopolize homeownership. And so again, the goal of this particular alternative is to mitigate those impacts. My stakeholder is Nikki Zanchetta. She's right here up in the front row. Say hi to Nikki. Nikki is a planner at a consulting firm focused on housing element updates in California. Formerly, she was a regional planner at the San Diego Association of Governments, correct? Awesome. She's actually a friend of mine. We've spent a lot of time at bar trivia discussing our love for walkable cities and public transit. So anecdotally and through this project, she's given me a lot of great information and knowledge on these issues. And her, her passion and her patience for working in this area is really critical to solving the housing crisis. So really grateful that you're able to be here today. So let me get into it. I broke this down into 3 steps. So step 1, well, for all of our steps, I'm going to summarize them right here and then get into a little bit more detail in the next few slides. So if you have questions, I will likely answer them in the next few slides. So step number 1, this is the most comprehensive and important element of this alternative, which would be requiring input, public input only at city and county level jurisdictions and only for projects that propose changes to zoning, only for zoning change proposals. So what this would do, it would eliminate our current approach, which is a project by project basis on which we approve housing projects. That's very tedious. It's very slow. It's why we're having, it's a reason of why we're having this conversation today. Step number 2, it would require that all residents, not just property owners, have their opinion solicited when these changes are proposed in communities. And finally, step number 3 would require a city or a city council or a board of supervisors to have a much stricter adherence to rules around public comment and potential appeals to these proposals in order to prevent, again, appeals and information that could possibly have been sourced by p-value hacking. If you don't know what that is, again, I'm going to get into that in the next couple slides. So step number 1, again, this is the most comprehensive step of this particular alternative. So it would entail eliminating public hearings for any housing projects planned to be built within existing zoning limits. So again, this would be a really sweeping change to implement in the state of California. Public input would only be required for zoning designation changes. So an example of that would be if a single family zoning area was being changed to a multifamily zoning area, that would require a public hearing. We essentially, again, eliminate public hearing meetings for almost all other zoning/permitting decisions. Now, why are we doing this? A NIMBY might ask, how on earth could you do something like this? First and foremost, this really cuts the bureaucracy that we're seeing in these approval processes. It would speed up the approval for affordable housing projects. And there's a lot of evidence to support that larger jurisdictions such as city councils or county boards of supervisors are more likely to support housing projects than smaller, more neighborhood level organizations like an HOA, for example. While, of course, HOAs don't have the decision-making authority of something like a city council, they nevertheless are a hotbed for NIMBY attitudes to grow. And so this would be a first step in moving more towards city, county, broader level reviews that have a greater chance of paving the way for affordable housing projects. And there's a lot of examples to support this. Minneapolis, for example, in 2018, their city council passed a really sweeping plan to totally abolish single family zoning by 2040. So despite a lot of pushback and opposition that they received from people living in single family areas, again, their city council nevertheless approved that plan. There's also a lot of evidence in California to support this idea. Recently in Sacramento, there was a project proposed for, I believe, a five-story affordable housing project in the Woodlake neighborhood, which is a pretty nice area around here. And there was a lot of NIMBY opposition, but again, the city council nevertheless approved that plan. So I read through a lot of other examples throughout the state in Northern and Southern California, got to represent everyone, that just really showed that despite a lot of HOA, NIMBY opposition, a lot of times the cities and the counties will end up approving these affordable projects. And in conversations about this, Nikki brought up the importance of focusing reforms like this on all housing projects in order to, of course, increase the supply over time, which we all know from our economics lessons will decrease the price. So that is an overview of step one. Step two would be requiring the solicitation of input from all surrounding residents in the community of such proposed zoning changes. Now, there's some studies that across the country that have pointed out that oftentimes only property owners are required to be notified of projects like this. While this isn't necessarily the case for a lot of local governments in California, I find it would be really important to have a state mandate requiring that property owners and renters in these areas are notified of zoning changes around affordable housing in order to correct for past injustices and to correct for the fact that these groups historically are not included in these conversations. Am I still on? Oh, that's why I was getting some weird looks, because I'm still on step one. So right here is pretty much what I just described. You can read through that a bit. And San Francisco County has some interesting resources and examples related to this. So step number 3 would require a decision-making body's strict adherence to guidelines around public comment to start with. In some of my research, I watched some Planning Commission public comment sessions for Sacramento. In one instance, I saw a commissioner use their discretion to give one person over 6 minutes of public comment time, which is quite a lot, in my opinion. And since these planning commissioners are oftentimes able to use their discretion in how long someone can give public comment, that really gives room for a lot of implicit bias to take place when there's no guardrails to protect against the commissioner maybe giving their wealthy neighbor a few more minutes of time versus someone that they don't know in the community. So part of this alternative would implement really strict requirements around this, making sure that each person gets 2 minutes, no exception, for public comment. And finally, the last part of this alternative would have to do with restricting local government's use of data that has possibly been sourced from p-value hacking or pre-registration in appeals or just general opposition to affordable housing zoning changes or plans. And what that means is that this really gets at the idea of when NIMBYs and developers commission study after study in order to find an answer that they're looking for in order to prove their point. And by the end of that, the reality is that they're producing a false positive and their data is not necessarily accurate. And so there is a great example in San Francisco. Recently, Assemblymember Matt Haney had a bill signed into law that would limit the city of San Francisco's ability to deny permits that have already gone through the approval process if they're being appealed. So that is actually already the case for every other city in California, just not San Francisco, which is why he did that bill. And so it's a great reference for implementing a statewide mandate of something with some more rigor to really strengthen this idea and allow for more affordable housing. So now getting into the implementation and analysis of this alternative, the costs are fairly minimal to the taxpayer and to local governments. City councils and boards of supervisors would, of course, incur some minimal implementation costs. What's really important to think about here is the enforcement and implementation, because the efficacy of this alternative really rests on the buy-in of local government. Their willingness and ability to enforce this with rigor would really determine how successful something like this would be. And of course, this also relies on the compliance of developers and the general public. I'm like double checking that's going to the next slide now. So I organized my thoughts and everything I just presented to you in a logic model here to kind of show and organize why this will work, why this would be successful. Overall, what makes this most successful is that it cuts bureaucracy at a rate that we really haven't seen before in the development of affordable housing. It is important to note the mediating factors here, including existing bureaucracy at the state and local level, local resistance to state directives that we often see from local governments when state mandates like this come into place, NIMBY pushback, of course, that's why we're having this conversation, and any unknown costs that might be incurred by local governments. Okay, getting into our CAM analyses. So the quantitative CAM, we scored this pretty high. As you'll see here, we have a 3.95 total score for this particular alternative. And then our qualitative CAM will, of course, get into why we scored it as such. So again, it has a pretty high cost effectiveness rating because this would really be minimal cost to the taxpayer and conceivably even lower costs to local governments over time because theoretically they're spending less time in public hearing meetings. For equity and for administrability, we scored it moderately. So my thought process was, while these reforms would go into effect for all local governments, they may not necessarily target those high value neighborhoods that Shoshana was mentioning earlier. However, we scored it still on the moderate high side because it would really increase the pace of developing affordable housing. And administrability, similar to what I was discussing with implementation, You know, we'd have to rely on local governments to really strictly enforce this. But again, administration costs relatively low. So wrapping up here, all of these ideas, steps 1, 2, and 3, all came from this book called Neighborhood Defenders by Catherine Einstein, published in 2019. It examines huge swaths of data around how NIMBYs dominate land use politics, keeping us entrenched in segregation. Chapter 7 in particular analyzes how we can reform public review and public comments, and really states very nicely all the ideas I shared here. And then a lot of the details and more detailed components of what I've shared came from my research and analysis on affordable housing projects in California, current state and local laws, and of course the input from our stakeholder. Yeah, so that is the origin and inspiration for this alternative. And then wrapping up here, just wanted to leave you with some closing thoughts. So I think it's important to remember that the crux of an alternative like this rests on the fundamental constitutional rights to the freedom of speech and the freedom of assembly, and the government's obligation to protect those rights, and those rights being protected for all people, including NIMBYs. So how do we keep that in mind while also combating these tedious NIMBY aggressions against affordable housing? I think this approach is a start at doing just that. And additionally, in the development of reforms like this, we really need to ask ourselves, you know, how do we engage those who might be indifferent to public participation? I'm sure we all know very well just how hard it is to engage the public in our government. To really increase civic engagement can be a difficult task, especially for people who might be apathetic, and especially for people who might not trust our government institutions, rightly so, due to historical injustices. So these are important things to keep in mind when we're discussing reforms like this. However, I think that this particular alternative is especially suited to increase affordable housing development by cutting bureaucracy and including previously marginalized communities in that discussion. That's it from me. So thank you.
That I failed to mention, if you want to ask any clarifying questions, you know, that in the middle of the slide, feel free to, but there'll be an extensive discussion at the end.
Okay, cool.
All right, I'm Matthew Melville. Thank you for coming. I'm going to be addressing the second alternative, and that is reforming CEQA to ensure that we can build for California's future while preserving our environment. I want to thank a couple of our stakeholders who were able to come out. I want to thank Linda and Jeff. Appreciate you guys being here. We're really lucky to have someone of Linda's breadth of experience. She's been doing the housing community development for a long time, and a great deal of experience. And so I met Jeff first when I was applying for a job with the North State Building Association. And Jeff also has a lot of experience in the housing space, and is currently raising a family with his wife in Roseville in a house, which is our goal. Awesome. So I wanted to go into a brief history of the California Environmental Quality Act, CEQA. So first off, what is CEQA? And the purpose of CEQA is to be a framework to let the government and the public know if a project is likely to create significant environmental harm, and to help preserve California's resources for future generations. It was passed in 1970 and signed into law by then Governor Ronald Reagan, which I find a lot of people are surprised by. Back in 1962, Rachel Carson had published her seminal book, Silent Spring. And at that time, that was probably about the height of the environmental movement. And so it was a lot more bipartisan at that time than we tend to think of today. It was modeled after the National Environmental Policy Act, NEPA. And originally, it just affected large-scale government projects. So it was aimed at building things like bridges and ports and stadiums, highway systems and that kind of stuff. And the idea that the average citizen would have more of a say in the government projects. There was a big problem at that time, especially under Eisenhower and some of the later presidents, where they were building highways right through neighborhoods. And there was an initial push to give everyday citizens a chance to sort of look at the impacts that would have. Then in 1972, the California Supreme Court would massively broaden CEQA by interpreting a public project as any development that needed government approval. So that's just about everything. It won't likely affect you if you're trying to, put in an addition, because you need to show that the agency that you're bringing these things has the money to follow the CEQA requirements. But otherwise, just about everything else falls under CEQA. It gets amended all the time by the legislature, courts, and local jurisdictions. The bill originally wasn't that big. If you look at it now, it's over 100 pages with a whole bunch of appendices and everything else. And it makes everybody's jobs harder when it keeps changing on a year-by-year basis. I'm getting a lot of nods up here. All right, controversy. So the longer CEQA has been, the more controversial it's gotten. In a 2015 study by Holland and Knight, their land use law firm, they found that between 2010 and 2012, that less than 15% of the lawsuits filed in CEQA were filed by groups with prior records of environmental advocacy. So that leaves 85%. And while some of these were doubtless legitimate, that leaves a lot of room for a lot of NIMBYs utilizing CEQA protocols to try and slow down, delay, and stop development that they don't approve of. Also, 80% of CEQA lawsuits target infill development projects, while only 20% of CEQA lawsuits target greenfield projects. I want to go over what that means in a moment. So greenfield is, you've got sort of unspoiled land. Maybe you've been doing stuff, maybe you've been grazing cattle and whatnot, but essentially it's untamed. It's probably got trees and habitat for animals. And if you're developing it, it's probably pulling in the bulldozers and kind of going through and then turning it from more wild land into human habitat. It's considered by most environmentalists to be fairly destructive. Contrast that with the infill development. And infill means that you're taking land that maybe there's some stuff on it, maybe it's an empty lot, but it's surrounded by development. And you're sort of just improving it. So it's already part of the human environment and human habitation. And you're utilizing it for more productive use. And environmentalists are pretty unanimous that ultimately infill development is going to be a lot less destructive than the greenfield development. And we can see that most of CEQA is targeting this infill development, where if it was environmentally motivated, you would see more of it targeting the greenfield. And then there was a report by the California Legislator Analyst Office that found in the state's 10 largest cities, CEQA appeals delayed projects by an average of 2.5 years. And I don't have the numbers to quantify that, but that's a huge amount of time. And while that's happening, you're having to pay a lot of the developers, a lot of the planners. It's going through all just through all these processes, and all of that adds time and expense and uncertainty to these projects. And while California land costs are significant, and that's often held up as the reason that housing costs are so much higher in California, a lot of times that is a much smaller, that's a much smaller percentage of the premium that we pay here in California. And a lot more of that is up to these delays and just the cost of getting through all this paperwork, beyond the cost of land, beyond the cost of labor. Oh, and the first study, this is a graph from the first study where they were kind of breaking down. You can kind of see all these different sequel lawsuits. You can see them targeting energy. A lot of times they're targeting green energy. You can see going after schools and entertainment, and a bunch of different things. So I don't have time to go over all this, but this is a CEQA process in a nutshell. And this is a simplified process, and it's still pretty complicated. So the first step is you have to figure out if the activity is a project. You have to figure out if it's exempt. If it has public support, then maybe it's exempt. Increasingly, I talked a little bit earlier about how CEQA was originally aimed at large scale developments such as stadiums and highways and things. And increasingly with CEQA, we have exceptions where those don't have to go through the CEQA process. I know the recent Kings Stadium was able to step the CEQA process. And so increasingly CEQA is being used against a lot of these smaller scale projects and the housing developments, and it's not being used for the original purpose it was meant for. Yeah, so you got to figure out if a project will have a significant effect on the environment, which is really open to interpretation. And I'll get to all the different ways and all the different criteria you can do to look at that and how easy that is. A lot of times it will have multiple significant effects for multiple criteria on the environment. And then ultimately, you end up needing the studies and the EIRs. Those are the environmental impact reports. And everybody up here is nodding. It's a big part of CEQA. They involve a lot of documentation. And then if, again, they find that there's any significant impact, which they usually do, they often lead to expensive mitigation. And then you can see that there's a lot of times where you have to go through and the process can repeat. All right, so that's CEQA. So how can we reform CEQA? So I think a good place to start is that we can look to other states that have similar environmental legislation that maybe is working a little bit better than what we have in California. Specifically, I wanted to point out the New York's Environmental Conservation Law, the ECL. And there's two reforms that I'd love to take from that. The first is prohibiting anonymous lawsuits under CEQA. Right now, you can sue under CEQA. You don't need to put down a name, an organization. This is great for NIMBYs because you don't have to, you don't have to put your name on it. If you're worried about having affordable housing and having more minorities in your neighborhood, you don't have to admit to that. You can just sue anonymously under CEQA. And in New York, you have to put your name on it. And then additionally, tightening standing criteria. Standing is just your ability to sue and be recognized in the court system, so that a claimant must be directly environmentally affected or have a history to sue under CEQA. Get to that in a moment. And then the last is I talked about how much ambiguity there is in CEQA and how easy it is that there's a lot of different criteria and how easy it is to show a significant environmental impact. And so 3 of the criteria, the noise, the historic, and the aesthetic significance criteria, I think should be waived for infill development. Get to that in a moment. All right, so prohibiting anonymous lawsuits under CEQA. This would allow us to focus more on the environmental impact rather than NIMBY delay. It would expose a lot of things. For one, with CEQA, a lot of times developers have used CEQA anonymously to slow down other developers' projects and increase costs. You've also had, and then you've had, sorry, I forgot that. And I think it would also do a lot to expose self-interested parties, people who don't have environmental aims in mind. And then this is more of this is more of the political scientist in me, but a lot of times it's really hard to get a lot of good data on how many projects are being delayed by CEQA. Because of the anonymous lawsuits, it's hard to tell how many of them are environmentally motivated. But by removing the anonymous lawsuits, it would also allow the collection of much better data. And then tightening the standing criteria. We've had cases of people filing CEQA legislation because they were worried about the shade interfering with their ability to grow zucchini plants and a lot of other things. And being a gardener myself, I'm sympathetic. You need that sun, but it doesn't give you the right to block housing for, in this case, it was 500 students in UC Berkeley. And by tightening the standing criteria, it would require people to either show that there's an environmental, that they're personally affected, or that they would have to partner with an existing environmental organization, such as the Sierra Club, which uses CEQA extensively, and work through them. And this works really well in New York at reducing the number of lawsuits. And then just a statistic, I know you talked about the number of homeless in New York is really high, but the number of unsheltered homeless is really low. And it's much lower than California. And a large part of that is, I mean, there's a number of reasons, but the reforms allow them to build a lot more shelters and pursue their housing first model a lot more effectively. All right, I was telling you a little bit about a lot of the environmental factors and how open those are to interpretation. These are the 18 environmental factors of CEQA. And some of these are pretty straightforward. You probably guessed things like geology, soils, hydrology, greenhouse gas emissions, but hazardous materials, but also the aesthetics, the historical criteria, the noise, and there's a lot of these that are really open to interpretation. And they're left often for liberal interpretation by the California courts, and they can block a lot of projects. So I singled out these three criteria as being especially problematic. The first one is noise. And anytime you're going to have development, you're going to be generating noise. And then after you have development, you're going to be having more people. You're often going to be having younger people who are generally louder. You're going to be having more traffic. The fact is, if we're going to develop, noise is probably inevitable. And it's a major concern. If you're building an airport, that's type of environmental concern that people are going to have, and you might want to have that mitigated. But if we're going to be looking at infill development, I think it's too easy to trigger. And ultimately, if you're doing infill housing, I think that we should have an exception for noise, as we have an exception for a lot of things under CEQA. The second one is the historic criteria. So again, this is open for a lot of interpretation. A lot of communities are looking at their neighborhoods and they say, well, we have a historic tradition of only having single family homes or only one-story buildings, and a lot of these criteria, and it prevents them from developing the neighborhood and creating any density. In particular, right here we have the Queen Anne's or the Painted Ladies in San Francisco, which I think is one of the more sympathetic versions, and they're beautiful houses. And much of San Francisco, you can't touch these houses, you can't develop them, and they're lovely and they're part of the character. But if we're stuck with the same buildings that we had in the late 1800s, early 1900s, then we're never going to be able to support a population above those levels and develop. And then the final one is the aesthetic significance criteria. Again, it's often used kind of brute force. It can mean almost anything during an SIR. It blocks any density, just any change in the neighborhood. You can, if you can find a judge who's willing to interpret this liberally, you can block almost anything. And it's in the eye of the beholder. And so exempting housing from this would also go a long way. Okay. So back to the numbers. So you saw this before. So I think the cost effectiveness of the solution is probably the best out of all the alternatives. I'm sure with the changes, we'd have some initial costs, but ultimately, I think that will save money in the long run. I'll talk more about that in a moment. And then the equity, I think it comes the lowest in this one. Administratability, again, it's pretty high. And we end up with a 3.85, which you'll notice is a little bit later, a little bit lower than Shoshana's. Oh, sorry, than Shannon's. It's a little bit lower than Shannon's. But I think that we initially scored the cost effective a little low, and this is the most cost effective solution in a difficult budget year. So again, some of the initial administrative costs in the short term, I think you'll have some decreased costs in the moderate to long term, as essentially this is going to require less enforcement, less administration, and it should we should get some cost savings at both the local and state levels. The equity, I think it's the lowest on. It's going to lead to an increase in housing and infill development. It won't take away all the powers that NIMBYs have, but it will help. Ultimately, this is going to be relying more on the public market to solve the housing. And so it won't be as targeted as some of the other solutions. And then the last one is administratability. Again, this is high. Changes and exceptions to CEQA have been common, and these reforms should be easy to implement and stop enforcing. All right. In conclusion, this is reforming CEQA is a cheap solution. It's a market-led solution to the housing crisis. It'll be easy to implement and administer. We've already had major reforms to CEQA: 1972, 1976, 1978, 1984, 1989, 1993, 2010, 2019. So we're used to reforming CEQA at this point and carving our own exceptions in it. We're following the example of environmental legislation in other states. We're having a focus on infill development, so this shouldn't be environmentally destructive and might even help. So the $20 question is, if reforming CEQA is this effective and this valuable, why haven't we done it? And the biggest concern is the political climate. There was recently 300 organizations all came in and signed a Keep CEQA Safe petition. And so the political climate, I think, is the biggest worry here. But I'll let Shoshana address that more. Thank you.
Hello, everybody. How you guys doing? Yeah, thank you for coming. Thank you for the stakeholders. I know having you here on a Tuesday night, may not be ideal, but I don't know how interested you guys are in these policy topics. But my name is Luiz Torres. I am here to present the STIC approach. I will elaborate more on why I chose to keep that name. It's a more assertive mechanism to compel cities to develop their housing plans and establishes more creative legal incentive for them to comply with their regional housing needs. So a building permit moratorium. This specifically is to target NIMBYs. And more specifically, it will include a mechanism or trigger from the HCD, the California Department of Housing and Community Development, to a non-compliant housing element municipality, stating that non-essential building permits are halted. What does non-essential building permits mean? You know, if you want a new deck, if you want a pool, you want to renovate your kitchen, that does not count unless it's for health or safety reasons. That moratorium would be in effect. The second mechanism establishes in statute that the California Attorney General can pursue litigation if these municipalities ignore these building permits moratorium and would allow the AG to redirect percentages of municipalities' property taxes to a local housing trust. And I will explain why this is the mechanism that I chose. It has to do with the policy origin. I want to introduce my stakeholder, Dori Ganetsos. She's right there, right in the corner. Thank you, Dori, for coming in. Her current role, she's a senior consultant at the California Assembly Committee on Housing and Community Development. She specializes on land use planning and housing policy. Prior to this, she worked on policy at HCD. And then a couple years back, she worked for the San Francisco Planning Department. And you can see right here her education. From her master's to her bachelor's, she's very qualified and provided a lot of help in terms of developing this policy proposal and determining what's the correct mechanisms and just what would work best to mitigate the influence of NIMBYism. This policy origin. So in December 2023, there's a Los Angeles County Superior Court judge who came down with a ruling that restricted Beverly Hills building permits. In this specific case, they restricted all building permits except those that created extra rooms or ADUs, which was fitting for a municipality that was non-compliant to HCD's notifications. It was a series of letters that said, Beverly Hills, you're not compliant. These are the steps you can take to be compliant. And now in 2023, they spent over 2 years ignoring or just not being able to comply or just not working with HCD to come to this conclusion. And this is the first injunction that marked the first time under the California's housing element that a municipality's building permit authority was revoked. And this court case, Californians for Home Ownership versus City of Beverly Hills, kind of kickstarted this process. I will have to commend the Californians for Home Ownership. They are funded by the California Association of Realtors. Aaron Stump, thank you for highlighting that for me. On their actual website, they have multiple cities that they have pursued litigation against because their housing element is non-compliant. And that kind of goes more to the point where why are we having these nonprofits have to do this work when we have California Attorney General that can pursue this kind of litigation on behalf of the people of California. Going more into the background, what is the regional housing needs allocation? It goes through a determination process through the HCD. This is more demographics and housing needs in the region. Kind of funneling it down a little bit more specific. It's the Council of Governments, which helps allocate these housing needs throughout California. In California alone, there's 35. This is countrywide. There's different council of governments, and they go more into specifics of cost burdens, proximity to work, population density. They consider all those factors. There's affordability levels in RENA, most notably very low, low, moderate, and above moderate. The ones that are probably the most difficult to achieve are the very low and low. That's more due to market concerns. It's so expensive to build housing in California. Why would a city want to allocate those specific housing units to be of that designation, which is in the case of Beverly Hills. And lastly, the implementation. So jurisdictions must update their housing elements to comply with the RENA requirements. And I will go into what these housing elements imply and how difficult it can be for cities to comply to them. So California Housing Element Law It's been around for a while, since 1969. So this is nothing new. Back then, it was just to help cities plan for future housing. There wasn't really too much teeth into it until more recently. It is a more market-based strategy. It gives discretion to the cities to see how their city is going to look in the future and plan for that. Notably, I was part of Anaheim, the city of Anaheim's housing element discussions back in 2021. It's a very community-based process where regular public goes up to and talks to these experts in the cities and say, we want more single-family housing. I can't afford to live in the city anymore. We need more very low or low income-based units. It's a very colloquial process, and I was happy to participate all those years ago. And these happen in cycles. Right now, we are on the 6th cycle. As we can see here, started in 2021. And as you see, when that lawsuit was filed against Beverly Hills, they had been non-compliant for about 2 years, which kind of shows you how like even in the middle of this cycle, there's a lot of cities that are not compliant. Last time I checked, I think it was yesterday, HCD's website on which cities were not compliant. There's a total of 34. Unfortunately, my hometown, city of Anaheim, is not compliant, which I am very disappointed in. But we will go more into that in a sec. 34. It's not in terms of geography, in terms of what has been submitted and what has been deemed as non-compliant. There's a lot of them that are out of compliance, but they're in review. So that's the data that's I found on HCD's website. There's way more than that, but it's the difference between them being in review and being submitted, and HCD saying, no, this is not compliant, work on it, and come back to us later. Thank you for the question, by the way. This is a screenshot of the city of Anaheim's RENA allocation chart. It kind of shows you how the different income levels are separated. When I first saw this a couple years ago, I thought it was very interesting how the city had all these allocated. And more shockingly, when you actually see the data of what they've actually built, it's more a whole bunch of above moderate, and then low and very low is in the double digits. So it kind of shows how difficult it is for cities to actually go through with these plans. And this is just a map of the proposed RENA sites found in the housing element. Just for you guys' reference, this is Disney right here. So you see a lot of housing development happening around Disney. This specific demographic is the Hispanic population. In these housing elements, they use different demographics that vary, that is eventually sent over to HCD. The documents are, the one that I have from the city of Anaheim is about 400 pages. So all that has to be reviewed by HCD. The city of Beverly Hills case results. So as I mentioned, when that lawsuit came through from the Californians for home ownership, that happened in December of 2023. This is one of the charts that I found in their updated housing element, which is in review. It is still out of compliance, but they're still trying to see if this new version that they submitted will comply with the RENA allocation. But what I will admit, this is a sample size of 1, because this was the first time an injunction was passed that halted building permits. And because the city of Beverly Hills was galvanized to actually produce a document for HCD in about 3 months, more or less, it kind of demonstrates the power of halting those building permits as a consequence of not being compliant with their housing element. The role of the Attorney General. The primary purpose that I added this mechanism into this polished proposal is cities can ignore these building permit moratoriums. If not wanting to comply with RENA and updating housing element, they can just keep issuing building permits. Because if from HCD's perspective, it would be a notice saying that, that there's a moratorium that's going to be established. This way, there is more teeth behind this policy proposal. It specifically since HCD will have some discretion in saying, you've been working with us trying to comply, even though you're not compliant, compared to a city like Beverly Hills that just did not want to be compliant and was kept dragging on the housing element update. By allowing the AG to redirect these percentages of municipalities' property taxes, it hits NIMBYs at their core, because most NIMBYs are homeowners. And using that property tax money, it's the money that they use for eventually will be allocated for city services. And by allocating that money, or by allowing this lawsuit to go through, a local housing trust will be able to grant states that money to produce and preserve affordable housing. So it kind of goes in kind of loop if cities keep being non-compliant and not updating the housing element for their designated allocation. Well, that's some of the teeth. This is my qualitative CAM. So in terms of cost effectiveness, my apologies, it's not low, it's actually high. It's very cost effective because it uses established HCD staff. Issuing that notification to these municipalities isn't too much of a staff burden. HCD already regularly communicates with municipalities regarding the status of their housing elements. And regarding the AG already has allocated funds to pursue lawsuits against cities when they are not compliant. In some cases, one of the main ones are the city of Huntington Beach. So in terms of cost effectiveness, it would be high. In terms of equity, the cities that would fall under this policy proposal are more wealthier. The cities that do not want to be compliant, either because they want to keep the community character, or they're not going to say it out loud, but they don't want those very low affordable housing units in their community. So these will be close enough to city centers where jobs are located, but in terms of being accessible as being in a big city, I do not think that equity criteria would qualify. Although a lot of these cities would be more low crime rates, well-performing schools, and relatively less pollution. In terms of administrability, because there's already a mechanism in place in terms of HCD communicating to the cities, and the AG already pursuing some litigation against some jurisdictions regarding the housing element law, it'll be very feasible for them to kind of swivel into this space and be able to implement this policy. This is my quantitative CAM. So in terms of cost effectiveness, I put a 4. Not much staff time is going to be used in implementing this policy. Equity 3, just because of that job center piece. And administrability, I put a 4 because it'll be very easy to add that to the responsibilities that these current agencies already have. So I have a 3.55, which I believe might be the lowest. So in conclusion, this stick approach, which I will say it's 2 stick approaches in terms of the building permit moratorium and the role of the AG. It does use existing agencies, so it wouldn't be too much of a cost burden. It would incentivize more wealthier, non-compliant municipalities to update the housing elements and plan for these all the different allocations in their city. Having a more diverse units available for the public. And it already uses allocated revenue. HCD and the AG already have money for their staff in order to implement these kind of policies. It wouldn't be as much of a cost burden. And lastly, it forces planning for low and very low affordable housing allocations, which is the crux of NIMBYism. They don't want these type of units in their community, and because this targets these more wealthier cities, it will provide the opportunity for these cities to finally comply, unless they either want their, they're not going to get their permits for their pool or their new deck, or they want to get some of the property taxes taken and be allocated for a local housing trust that will, help preserve affordable housing in the future. Thank you.
All right, I'm going to wrap us up here before we have a slight break. So in conclusion, just to compare all of our policy alternatives, I highlighted sort of the highest scoring for each category, each policy alternative. In the first category, CEQA reform scores the highest, just because, as Matt stated earlier, it's going to have little cost given the amount of housing it will actually produce. All they need to do is just stop enforcing CEQA rather than start doing something. So that's very little cost, but the amount of affordable housing developments that will be able to move forward without the CEQA barriers will likely be substantial. And then for our second criteria, equity, the public review reform scored the highest, not just because it removes all these barriers for affordable housing developments, but because it helps include some voices that weren't previously included, and hopefully increase the amount of units in, as Shannon said earlier, all neighborhoods, but especially those neighborhoods where we see a ton of opposition coming out to these local meetings and trying to curb these projects. So by reducing their opportunities to have that extra influence, it will likely increase the amount of housing units we see in those neighborhoods. And then on the last, we had a tie. We had both CEQA reform and the stick approach score the highest on administratability, because again of those existing mechanisms, and neither have to set up new regulations or new methods. It will be likely absorbable burdens for the staff to figure out their new logistics, and absorbable costs to actually implement. But overall, in conclusion, our highest scoring one is our public review reform alternative. And with that, we also did a couple of alternative weighting mechanisms. So I was just curious what would happen if we move the weights around a bit. So for this one, I pumped up the weight of the efficiency to about 50%. Previously, it was 30%, and then reduce the weight for the equity and for the administratability by 15% for equity, and I reduced it by about 5% for administratability. And we do see some substantial changes. Most notably, the CEQA reform scored highest because it had the highest cost effectiveness of all the policies. But because they all don't have a ton of costs associated with them, that's why we didn't originally weight it as high. But if we had weighted our concerns with cost for the amount of units we're producing, our CEQA reform approach would have scored the highest. And then this last alternative scheme, I increased administratability up to about 40%, and then reduce equity to 35%, and reduce cost effectiveness to 25%. And CEQA reform also scored the highest on that measure, again, because, as I stated, there's very little administration changes other than just don't allow these lawsuits to be filed, or exclude these things from the CEQA review processes that happen at the local level. So all that taken into consideration, is also important to consider political acceptability of these reforms before we make a final recommendation. So for public review reform, I thought, or we all thought, that it would score the highest based on what we're familiar with in the California state legislature and what the governor has historically supported. And then on the lower side, CEQA being the lowest and the stick approach being slightly higher in terms of political acceptability. And I'll get into the reasons next. So in terms of public review reform, there is a host of example policies we have passed to reduce public review barriers. Most notably, SB 35, passed in 2017, made a huge change by exempting a lot of affordable projects from public review if they met certain labor requirements. And then that was followed by SB 9, which it says that it eliminated single family zoning in California. It didn't really, but if you're a homeowner, you can now subdivide your lot up to 4 times. If you're a developer, you cannot. You must live in the property to do that. So that is the catch with that one, but you can do it with no public review. You can just go and apply for a permit and divide the lot. And then recently, AB 2011 and SB 423 were also major reforms. AB 2011 most notably allows housing in commercial zones without public review to change the underlying zoning. For CEQA reform, while we have a history of exempting housing from CEQA in general, actually reforming CEQA itself has proven to be politically a lot more challenging. It's considered a bit of a third rail here in California. It's up there with Prop 13. So I put an example up there with AB 1449 that was passed last year that exempts certain 100%, meaning all units are at the affordable level if they meet certain labor requirements from CEQA. However, actually amending CEQA itself by eliminating those extra, like the historic review parts or the noise, preventing anonymous lawsuits, that's proven to be much more politically challenging. And I did see a history of attempted legislation that failed pretty early in the process because of those political challenges. And then lastly, the stick approach. It would not apply to as many areas in California. There would be less cities affected, but these are wealthy neighborhoods that are probably politically well connected and can still raise a ton of concerns. In addition, constituents themselves might reach out knowing that their building permits might be halted. So knowing the political climate of those bills, the political climate of those alternatives, we decided to finally recommend public review reform, again, weighing how much it will likely open up development, but knowing it's politically feasible in the near future to pass. And in addition, by making those reforms to who is actually invited and what types of studies people can commission will also go a long way in terms of having more fair hearings and then having them at more of the city level rather than just the neighborhood level would capture more regional perspective rather than just what this particular neighborhood thinks, because housing is at a more regional level in terms of being a problem. But if we're reviewing at a more neighborhood level, we have a much more constrained perspective, especially in terms of whether NIMBYs who would like to move into the neighborhood would attend something like that. So while there is, as Shannon reviewed, kind of an upfront investment, local governments need to make the changes. It might take them a little bit of time, cost them some money to do so. They aren't substantial, and it will likely go a long way in increasing our housing supply. All right, so that concludes our presentation. And I think we are going to transition to a short break, and then we will have our panel discussion.
Okay, let's keep it cool. Thank you. I know it's the most difficult to go first, and you guys did an extremely well job. Thank you very much for doing that. Appreciate it. Set a nice baseline for others to follow. We're going to take a break for about 15 minutes. I think we have enough time to do that. So we'll come back, let's say at 20 to 8 and probably go, an hour, maybe a little bit longer if the discussion is going well with our panel. So hope you guys can stick around for that and the people on Zoom. Let me just give a little bit of housekeeping to the students, right? So what I'm going to do is fill out my rubric on your presentation and send your grades within a day or two. So look for that. But I'm also going to offer some comments on your PowerPoints, right? And then you'll have the opportunity to respond to those. I'll give you an entire week to do that. So whenever I get it to you, you'll have a week to get it back to me, right? And then what I also like to do for everybody in the audience, both for the Tuesday and the Thursday class, I'm going to send a list that would list what I thought the group did really well. And some things that, other groups may want to think about perhaps in a few changes, right? No dig on you, right? But it's just things that I noticed that could slightly be changed for suggestions for other groups. So I hope you'll find that helpful. And I'm going to ask Shoshana to try to produce this video very quickly so it will be up for others to take a look at it, right? If they want some examples of it. It's just a matter of slicing the end, the beginning and the end off. And by the way, we are going to turn off the recording for our panel discussion, right? So I ask that you'll be willing to talk freely. And oftentimes people in the panel will say, this may not represent my employer, or this may not represent my boss, but these are my feelings about it. So no reporters in the room, no need that we're going to have this discussion often. We like to have a free and fair exchange, a critical discussion of this. And that's what we brought you in. To me, the panel discussion is the most interesting part of this, right? To hear your reaction to it, the methods, what the student did, and then the final conclusions. And I think once was mentioned, right? We made a recommendation. The economists call it the $20 bill test, right? They see $20 on the sidewalk. They don't even stop to pick it up. It must be a figment of their imagination because plenty of people have walked by and nobody picked it up, right? So, this is something that's been thought about for a long time. What's the reason why these reforms are not being adopted? We really would like your input on that.